Well, thanks a lot for that warm welcome. I'm very honored to have the occasion to speak to you on the seminar and congress you are holding these days. And there's just one sentence I think I could join my colleague Bielefeld in when he just said, I was in Malaysia twice. I share this experience with you, but apart from that, my topic will be quite different from yours, although it's connected to human rights as well, because I was asked to talk to you about the efforts within Europe and Germany concerning anti-discrimination legislation. And this term refers to anti-discrimination in a private context. That means between individuals. So imagine somebody who's refused access to a bar or discotheque on reasons of ethnic origin, or somebody who finds he or she has to pay higher premiums in a health insurance than somebody else, for example, of the opposite gender, which is a big topic in Germany. So now the next about 30 minutes plus a little occasion for you to join in a discussion will be dedicated to the relationship between private individuals. So not the classical human rights idea of the state being responsible for assuring that human rights are not violated, but the same is true for individuals who should not discriminate against other individuals on certain reasons. And I prepared a little paper. I guess you've all got it, or at least seen it, that assembles the efforts by the European Union on anti-discrimination. And my first question is, does anybody know where the word discrimination comes from originally? What it originally means? Anybody with a Latin language background? Sorry? Long ago. But yeah, it means something very basic, and that is to distinguish. Just to distinguish. The Romans used this word when they put their hair into two directions. They discriminare means just to put apart, to distinguish, to make a differentiation. So originally, this word had not any negative sound to it, whereas nowadays, obviously, as you can see, because the European laws are called anti-discrimination directives, this is something we want to eliminate in private relationships concerning certain aspects. And these aspects or factors are typically such as you cannot easily change them. Most of them cannot be changed at all, like your ethnic origin, your sex, your sexual orientation, the fact if you are physically challenged or not, and even religion that has just been treated is a topic where you could argue that it might be easy in your own mind to change a religion or to become an atheist, or the other way around, to become a Muslim or a Christian or whatever religion. But some people say this is not as easy as that. So the anti-discrimination legislation starts at a point looking at factors which the individual person cannot, or at least cannot easily change. And obviously it is weighting very heavily if somebody comes along and says, oh, I don't like you because of your ethnic origin, so I won't give you access to my discotheque, something that has happened in many countries, including Germany. And the same is even truer when you think of very basic and essential goods like the access to housing. So if a landlord feels he doesn't like women or homosexuals or people from a certain ethnic origin, and he says, no, you won't get this flat, which is interesting for you, because of these grounds, that is something that hurts obviously, and is a slap in the face, to say the least, for people who feel distinguished in a sense that they feel excluded from goods and services. So why Europe and Germany in the title? Those of you who have been working on European law know that the European Union has the competence for legislation only in some very basic matters, which do not include the general rules of contract law, but the European Union has authority to give directives. That means they set rules which have to be transformed in the individual countries, and this is something that has happened in all the 27 members of the European Union, but the national parliaments may decide how strictly they impose the rules. There is some scope of discretion which has something to do with the fact that, in contrast to the United States, for example, the European Union is not, or many say not yet, a state in itself, an authority that can rule on matters such as private law. So, to come back to my point, European efforts are being made in 4 directives, which you find printed in the annex to my little paper, which is just being distributed to you. So those of you who want to refer to these later on may have a look at the internet if you are interested in them. What is important now is to be aware of the factors which count as factors that should not be a reason for distinctions, for discriminations of people. It all started with racial or ethnic origin, and there's a long debate, which I can't go into right now, about the correctness of the use of the word race and racial. That's a very complex discussion. The fact is that the directives use this term, and they say it is necessary to use this to fight against racism. In many constitutions, including the German one, you will also find this term, which has recently been very much controversial. A second directive concerns equality between men and women, and that especially in the field of labor law. But the most recent, which is number 4 of the directives I mentioned here, is quite comprehensive because it concerns equal treatment between men and women in all goods and services, which include, for example, access to insurance or something you might perceive as very basic, but nevertheless there's a discussion about this. If there are special parking lot spaces reserved for women for security reasons, it has seriously been argued if that is discriminating against men who are looking for a parking lot and won't find this. So there's a discussion about all of these topics. And the last step, which has not yet been transformed in Europe, but it has been transformed in Germany, because you can see this in the German General Act on Equal Treatment, which I printed out as well, concerns a very comprehensive rule which says it is illegal to discriminate in all contexts of a private relationship where generally, usually, the individuality of the person is of no or of minor significance concerning aspects like religion or belief, disability, age, sexual orientation, and gender. So you have a very comprehensive new approach. And the German parliament, after a long debate, decided to put this already into force right now, although in the whole history, Germany was pretty late in transposing the directives. But then they said, now we'll do the full thing, and the European directive is still a work in progress. But the idea behind this is to have a comprehensive set of rules which makes it possible for a judge to control the behavior of private individuals between each other.